It's not always about what's said, but what's not said as well. Hi, and welcome to the Law Simplified, the world's largest independent online law school platform. I'm your instructor, Shraveen Bandardanayaka. The practice of law is about facts, arguments, and more importantly, the presentation of those arguments in a convincing manner to a court of law. Do this correctly as a solicitor or a barrister, and your client would be successful. Do this in a lackluster or a subpar manner, and in some instances, it might not just be that your client loses out on money, he or she might actually lose out on his freedom as well. If you like the type of content that I make on this YouTube channel, do subscribe to the Law Simplified and leave a comment below of what other types of content you'd like to see. If you are a first, second, or third year law student, as well as a legal professional wanting to upskill himself, I would highly recommend having a look at the comprehensive online law school platform, complete with theory, tutorial, and workshop lessons based on the actual one-on-ones that I've conducted with first-class law students globally. There are two words that I want you to critically think about: contextual deduction. What do I mean by this? More often than not, when it comes to my fast track and masterclass students, they tend to look at examination questions and even assignments that have been handed over to them by their universities as a means to an end. They consider it to be something to complete, techniques to be learnt in order to read such questions and then provide a response to and then move on. In reality, much like any other academic or practical course that you might do in any other subject area, these examination questions as well as assignments that are provided are meant to stimulate your analytical thinking and to make it possible for you to look beyond just the very technical, very clinical aspects of the subject area, in this case law. What I mean by this is it's practice for real life. When you look at an examination question, when you look at a fact pattern scenario, always think of it as a dry run for real life. And the most successful students, those who get a distinction, a high distinction, or a first-class law degree, tend to not focus really on the facts themselves and just address that with the law, but start reading between the lines and dissect a particular fact pattern scenario for much more than what meets the eye. Now, I know that on many occasions, myself included, lecturers, tutors, and academics would ad nauseum have told you to think beyond, read between the lines, think outside of the box, and so on. But what I would like to do is to put into context, so to speak, what all of that means. The best law students, who then turn out to be the best practitioners in law, thrive on seeing things that others don't see. They are, for the lack of a better term, a magician of sorts in terms of facts and arguments. Their job in relation to a judge, the jury, and the court of law at large is really to provide context to something that is otherwise up in the air. This does not mean misrepresentation of facts. It does not mean stating an argument that is merely for the sake of argument, but rather painting a picture and a perspective that the court, the judge, the jury, and the public at large might not have considered or seen for that matter. If you ever get an opportunity, I highly recommend you watching the film, which is based on a book and also a play called 12 Angry Men. It's from the late 1950s, and in it, the entire setting revolves around a jury trial and the deliberation room of the jury, where a potential suspect of a murder who's been charged with murder is in danger of being convicted and possibly having the death penalty put upon him, if not for one sole juror who thinks otherwise. I won't spoil the movie. I would highly recommend you having a look at it as well, because it gives the best context to what this video is really about. Now, initially, I told you about the concept of contextual deduction. What this simply means is to help whoever you're talking to, whether it's a judge, the jury, or even in your everyday life, it might even be a colleague or co-worker, to take a step back, not be tunnel visioned by the facts or what they have heard, and look at things more broadly, openly, objectively. As an officer of the court, a solicitor or a barrister is to help the court seek and then provide justice. And in doing so, the most successful practitioners are able to provide this contextual deduction, the what-ifs of law. And by you becoming someone who is conversant in the language of contextual deduction, not only would you pass your exams, you'll ace them, and not only would you be successful in your profession in law, but you'll thrive in it as well. That being said, until the next time that we speak, have fun, stay safe, and as always, obey the law.